And indeed, in the present case, the appellant is being agreed by that order made by the SEBI on 21st January. So that order being affecting us, and we are being agreed by that order, we challenge that order before.
Under which provision, sir, is asking? Sir, which provision of the Act?
15D, section 15D of the.
So the provision. You have it. You have the book.
We have the SEBI Act.
Please read the provision.
Appeal to section 15D of SEBI Act 1992. Appeal to the Securities Appellate Tribunal. Save as provided in subsection 2, and any person aggrieved, subsection A, by an order of the board made on and after the commencement of the Securities Law, Second Amendment Act 1999 under this Act or the rules of regulations, or by an order made by the adjudicating officer. Your Lordship, this order has been described by the Securities Appellate Tribunal in the case of Suman Motors versus SEBI.
There must be some provision regarding SEBI passing orders.
Indeed, Your Lordship, SEBI is authorized to pass directions. Your Lordship, the powers and functions are described in section 11 of the SEBI Act, whereby it is authorized to pass orders. It has not been explicitly mentioned as order, Your Lordship.
Just be humble. Don't worry about this part. It's fine. Whatever is provided to you, that only you can have, not more than that.
The board may, for the protection of investors, A. specified by regulations, by general or special orders, prohibit any company from issuing prospectus, any offer document, or advertisement soliciting money from the public for the issuance. You wanted SEBI to pass this kind of law.
I beg your pardon.
You wanted SEBI to pass this kind of law. By your opinion.
No, Your Lordship, I am stating that the order passed by SEBI on 21st January. Indeed, Your Lordship, to protect the investors. We want that kind of order. Indeed, Your Lordship. security. In real life. Like to cite one case where it had similar facts. I also would like to draw your attention to the page 14 of the memorial of the practitioner. In the case of MS Sumati versus SEBI, where the SEBI had mentioned changes to the acquirer in their letter of offer, but they hadn't commented anything on the offer price. So the shareholder being aggrieved by that approach before the Securities Appellate Tribunal. So the Securities Appellate Tribunal held that SEBI not commenting on the offer price is actually endorsing that offer price. And so if we do not provide the shareholders a right to appeal in under the section 15T of the Securities Commission Act, then it would go against the provisions of the section 15T. So if we are being aggrieved by the offer price provided, we can appeal under section 15T of it. In the present matter, the SEBI has approved the offer price being provided by the manager of acquirer and the creditor. So we are appealing against that offer price, Your Lordship. Further, Your Lordship, in Nagarjuna Fertilizers versus Chemicals, it was stated that an appeal under section 15T could be made on any action or inaction of SEBI. So, hence the present communication dated 21st January by the Securities Commission to IRN is maintained. Your Lordship, the first point being the shareholders have a right to appeal before the tribunal upon non-satisfaction of the offer price. It has been stated in the same case, Amismati versus SEBI, where a shareholder who is not satisfied with the price has a right to appeal before the tribunal. Your Lordship. Further, if we go to the merits of the case, Your Lordship, the provisions under section 8, subsection 2, subsection E of SEBI Substantial Acquisition Shares Takeover 2011 rules. Under that, one parameter is mentioned as book value. So while considering these valuation reports, the manager, acquirer, and the creditor haven't considered the book value of the shares of the present target company. So it gives and in the case of JL Sultania versus SEBI, it was stated that if you don't consider any one of the parameters, then that offer price is applicable. Your Lordship, we would like to draw your attention to
once the shares are pledged, alien ceases to be a shareholder.
Your Lordship.
You are aware of that? Their case is that once the shares are pledged, alien cannot claim to be a shareholder and approach SEBI. You are aware of that defense that they have taken?
Your Lordship, they are contending that they don't have any share. They are not the shareholders. But
shareholders because they have pledged their shares.
Indeed, Your
What do
Lordship.
you say to them? Do you say that in spite of pledging, alien remain shareholders?
Indeed, Your Lordship. The contention of the appeal is that they are still the shareholders as they haven't invoked the same. Indeed, Your Lordship. Your Lordship, it further submitted in the case of JL Sultania versus SEBI, it was stated that some variations by valuers is unavoidable, but the variation cannot be very wide when the correct valuation principles are applied. In the present case, the valuation report provided by the creditor, manager, and the acquirer is rupees 50, 47 and all. But the valuation report provided by us, the independent valuer we had appointed, is rupees 150. So it gives it makes the appeal maintainable because there is a very wide discrepancy in between the valuation reports. So this gives
where is the valuation report? Can you show it to us?
Your Lordship, that has not been provided. Your Lordship, in the case of JL Sultania versus SEBI only, it was stated that the great disparity in the valuation itself furnishes a good ground for rejecting the reports. So the council concludes for the first issue that the appeal is maintainable before the tribunal because there is a very wide discrepancy in between the valuation report provided by the appellant and the managers, and also the regulations under 8(2)(e) of SEBI task regulation has not been followed, so the tribunal needs to look into the matter. If the Lordship doesn't have any renewed concerns, I will proceed to the issue 3. Whether the valuation report is mandatory. My co-counsel will be dealing with issue 2 and 4. As your Lordship, I forgot to mention that. My co-counsel will be dealing with issue 2 and 4. I will be dealing with issue 1 and 2.
Whether you have to consider it or not, that as a pledger, you have pledged your shares. Security of the eventual customer. So, who they can do the development, right? Now, as ledger, you are not divested of the ownership of the shares. You have just pledged. Do you or do you not have a right? You don't have to go into so much nitty-gritties of this case. This is absolutely like a web. You don't have to go into. Do you or do you not have a right to ensure that the shares fetch the best price? That should have been the core issue. Do you or do you not have the right to ensure that the shares fetch the best price? One big SEBI. SEBI is a regulating agency, statutory regulating agency. You as the pledger of the share, do you have a right?
Indeed, yes, sir. We have the right as a separate.
And we looked into it under the Contract Act. That was not perhaps framed as an issue.
Your Lordship, it is stated that until and unless the creditor invokes and sells the pledged shares, we can redeem the shares until that point of time. So we can redeem and participate in the open offer process. And also we are the shareholders under the Depositories Act. We have been entitled as a beneficial owner of those 10% of shares. So we have a right to those shares and we can be agreed by that.
No, it proceeds on the ground that you have lost the right to redeem and they put it up. Your 10 shares per se. That you cannot stop you. Either you redeem or you don't. You have not redeemed or you redeem. So now that you are not able to redeem and your shares are being sold, do you or do you not have the right to ensure that the best price is fetched?
We do have the right, your Lordship. Because we are entitled as the beneficial owners and we are the legal owners of those 10%, your Lordship. So we do have the right, your Lordship. Your Lordship.
Counsel, have you read section 176 of the Contract Act?
Indeed, your Lordship.
What does it say?
It is pledged according to pledge.
What does it say?
Your Lordship, a notice has to be given before selling the pledge.
What does it say about the rights of the pledgee?
Rights of the pledge to sell the shares. So sell the pledge form.
Have you considered the decision of the Bombay High Court in Prime Broking?
Your Lordship,
Are you aware of this decision?
Your Lordship, my co-counsel will be dealing with the shareholders issue too. That's why. Issue 3, your Lordship. Issue 3, whether Your Lordship, the issue 3 being whether it is mandatory to provide the valuation report or not. Your Lordship, the Council of the Appellant contends that the valuation report is a relevant document and it is an indispensable document without which the open offer process would get vitiated. The Council would like to draw your attention to page 250 of the Compendium 1, where it has attached the sample valuation report, which states that the important things the valuation report contains. Your Lordship, the shareholders need to take a all-round. The shareholders need to be informed before taking a decision to exit from the shareholding of the company or not. Your Lordship, further in the case of jail Sultania, it was stated by the Apex Court only that even though the valuation exercise are done on the basis of principles of valuation, valuation reports cannot be ignored and not be liable to be set aside. Further, recent case in Your Lordship, Anup Kumar Seth versus TB and others in 2021, it was held by the Securities Appellate Tribunal that Availability of the inspection of the valuation reports to the appellant will be against the provisions and gross violation of the SAS regulations and consequently leads to vitiating the open offer process. Your Lordship, the valuation reports are mandatory and relevant documents to be provided in the open offer because it provides the shareholders a fair chance to exit and look upon the matter, how the shares are being valued. And it has been rightly held in the case of Anupama as said versus AB, which also states in paragraph 32 of that case that section 15, regulation 15.1 and 15.2 of the SAS regulations, it comes under the regulation 15 and 15.1 and 15.2 of SAS regulations, the valuation reports. And it is a mandatory requirement to be published to the shareholders, to provide them a fair chance to exit the shareholder. In the present case, your Lordships, if I would like draw your attention towards the para 11 of the moot proposition, it is stated that the three valuation reports were not included as documents to be provided for inspection. The three relevant documents were not actually provided for inspection, your Lords. The valuation reports. So it does. So the open offer stands vitiated for that reason also, your Lords. Valuation report being a mandatory requirement and they not providing it is a challenge against the open offer, and the open offer will stand vitiated for that reason, your Lordships. If your Lordship doesn't have any
in all these cases when you cited, if you have like a pleasure.
Yes, indeed, your Lordship, in the case of Anup Kumar Estate versus AB, it has the same case fact to ours, wherein it was a pleasure actually, your Lordship. It has the most similar facts with our case, whereas where the pleasure had actually, whether the question was raised and unavailability of your Lordship, the inspection of the valuation reports were not provided to the appellant. And your Lordship, it was not valuation reports were not provided by the manager to anybody. So it was questioned whether the question of unavailability of inspection of the valuation reports. So the SEBI stated accordingly. And it is a recent case, your Lordship, and 2021.
Wanted to say that there is procedural impropriety.
Indeed, your Lordship. Indeed, your Lordship. Indeed, your Lordship. Yes, sir. If your Lordship doesn't have any particular concerns regarding issue 3, I would like to call on 2 points. It was an honor to speak.
Wonderfully done. And I can say this, that this is the toughest or the most complicated of cases in the procedure by which both by cases are connected. You have done very good.
Thank you.
Honorable greetings to the bench. The council seeks permission to address the bench collectively as your Lordships. Much obliged, Your Lordship. The council,
The issues you are trying to address.
Your Lordship, the council for the appellant will submit for issue 2 and issue 4. Issue 2 is about whether the appellant is a shareholder under the provision of the SAS regulation and whether the appellant has any locus standi or not as an aggrieved party under the said regulation. And issue 4, your Lordship, for the kind reference of the honorable bench, it talks about whether SEBI has failed to perform its duty as a regulator by not following or violating the provisions of regulation 8, sub-regulation 16, along with regulation 32(1)(f) of the SAS regulation for current consideration, your Lordship. If there are no preliminary concerns, the council seeks permission to proceed with these submissions. Much obliged, your Lordship. Your Lordship, the first issue that raised is whether the applicant is a shareholder or not under the SAS regulation. And the council will submit and establish that the applicant is indeed a shareholder under the SAS regulation on 3 grounds. Firstly, that the applicant, Aryan, is a beneficial owner registered at the depository with respect to the demat shares concerned in this matter. Secondly, that where there is a right, there must be a remedy, and where the right has been affected, the party has to be considered as an aggrieved party. And your lordship, the council will finally submit the sub-issue that under regulation 7, sub-regulation 6 of the SAST Act, the applicant has been recognized as a shareholder and therefore has been agreed if such grievances are not taken into consideration by this honorable court. If there are no preliminary concerns on the grounds to be submitted, the council.
Ma'am, please explain how you are agreed.
Your lordship, the council firstly submits that the appellant is a registered beneficial, is registered as a beneficial owner with respect to the 10% shares which are not invoked even after the default was made. It was not invoked, but it was replaced to the acquirer through the share purchase agreement, your lordship. Is a beneficial owner, and since shareholder has not been defined anywhere, the council has relied on the judgment of Claring International of this honorable court, to which is also provided in the compendium for the brevity, your lordship. In case number 196, where the shareholder will be constituted, who was agreed to be a member in written and has been registered as a member in the register of members of the company. Additionally, for the demat shares, he is also the beneficial owner, registered beneficial owner at the depository. Now, your lordship, since on the triggering date or on the date the application to this honorable court was made or before the SAT tribunal was made, the shares, pledged shares were not invoked, and therefore the applicant was the beneficial owner. Secondly, your lordship, because he is a beneficial owner and because he still has the voting rights with respect to those shares, which is vesting with the pledger itself, which is the appellant in this present matter, he has all other rights, that is the corporate benefits and all other rights, including the right to challenge the offer price of the open offer in case it is aggrieving or in case it is aggrieving the value he is praying before this lordship to consider. Your lordship, the grievances is with respect to the fact that the honorable tribunal, honorable securities appellate tribunal has not recognized the appellant as a party and has not recognized his right to challenge the price which is the contention of the open offer, your lordship. Your lordship, the appellant has written a representative letter to SEBI contesting that the open offer, the price of the open offer, that it is not supposed to be rupees 50, primarily because your lordship, they are dependent on the intrinsic value and the valuation of the material subsidiary of the target company, based on which the appellant has taken the liberty of appointing an independent valuer who has also attested by a valuation report that the share price must be minimum rupees 150. Your lordship, such has also been submitted for the perusal of the SEBI board. However, your lordship, no further reply, neither any action has been taken by SEBI in that regard. And therefore, your lordship, the council for the appellant has filed the appeal in the SAT tribunal. In the SAT tribunal, they have dismissed the appeal because they have not recognized the locus standi. The council has appealed to this honorable court under section 15Z of the SEBI Act to take the relief claim that to recognize ourselves as the shareholders and an aggrieved party in this matter, your lordship. For the same, the council will refer to regulation 7, sub-regulation 6 of the SAST regulation, which is also provided in the compendium submitted on behalf of the appellant, which in this matter your lordship deals with a new condition, if I may. Regulation 7, sub-regulation 6 reads, any open offer made under the regulations shall be made to all the shareholders of the target company other than the acquirer, person acting in concert with him, and the parties to any underlying agreement, including persons deemed to be acting in concert with the parties for sale of the target company. Your lordship, in this regard, it is said that the open offer which is the primary concern of regulation 7, in that open offer, it is concluded that it is provided that all shareholders has the right to have the open offer. Primarily, your lordship, there is no provision in this regulation which states that a difference has been made between a pledged shareholder and an ordinary shareholder, your lordship. No difference has been made. Therefore, your lordship, the humble council is taking the liberty and has relied on the judicial pronouncement of this court at several occasions where it was construed that a shareholder for the purpose of demat shares will be the beneficial owner owner, registered beneficial owner on the triggering date of the open offer, which is, Your Lordship, 31st December 2021. Your Lordship, on that regard, it is submitted that since the exemptions under Regulation 7, Sub-Regulation 6, that is the acquirer, the target company and the person acting in concern or any parties to the underlying agreement, which is a share purchase agreement for this matter. The parties to the share purchase agreement are the buyer and the seller, Your Lordship. The buyer is the acquirer, the share is the debenture trustee acting on behalf of the creditor, Your Lordship. And therefore, the shareholder, the appellant for this present matter is not falling under the exemptions under Regulation 7, Sub-Regulation 6. And therefore, Your Lordship, he must be constituted within the bracket of all shareholders for the kind, for the preventive justice that this council is humbly seeking before this honorable court.
Tell us this.
Your Lordship.
In a pledge,
Your Lordship.
does the owner cease to be a owner upon making the pledge?
Indeed not, Your Lordship. Your Lordship, pledge is basically the delivery of the article or the goods for the purpose of keeping a promise or for this matter for the purpose of securing the debentures. Your Lordship, the delivery of pledge is merely for this matter it is a constructive debt. The inaction is a constructive debt.
What right the pledgee has?
Your Lordship,
Money has.
Your Lordship, under Section 176 of the Indian Contract Act, the rights of the pawnee has been elaborated. The pawnee is also the pledgee for this matter, Your Lordship. The right of the pledgee is twofold. Firstly, that he has a right to file a suit before the civil court so as to realize the debt or the default money. And secondly, right to invoke and upon reasonable notice, furnished of reasonable notice, he has a right to sell those shares so as to realize his debt. These are the rights provided to pledgee.
And then, before the sale is effective, what right the pledger or the owner has?
The right of the pawner are enumerated under Section 177 of the Indian Contract Act, Your Lordship. Under it has been provided that the pawner can either redeem those shares before the actual sale. The secondly, the pawner can also have a say with regard to the sale proceeds in case there has been already an actual sale.
177, what does 177 say with regard to the sale proceeds?
Your Lordship, it talks about the rights of the pawner. In that regard, Your Lordship, he has a lot of right, out of which this is also constituted under that.
Therefore, when the owner or pledger is unable to
Your Lordship.
redeem
Your Lordship.
and the money or pledging proceeds is sell and the owner realizes that this sale is being made at an undervalue.
Indeed, Your Lordship.
The owner can bring also a civil action and seek an injunction restricting that sale.
Your Lordship, the pawner or the pawner cannot file a civil action to challenge the offer price. Primarily because, Your Lordship, on the same, the council will provision of SEBI Act, if your council may seek the fair act for the matter. Much appreciated. Your Lordship, the council, with the due leave of the court, will cite Section 15Y of the SEBI Act, which states the civil court will have no jurisdiction where any matter or any suit or proceeding in respect of any matter falling under the SEBI Act, and because such regulation is a part of this Act, so any matter which is coming under within this Act, within this regulation, cannot be filed before a civil court, because additionally this Act statutorily creates the SAT tribunal, the SEBI board and other adjudication officer to take care of it, to entertain such matter. Therefore, Your Lordship, the appellant does not have any right before the civil court to file the appeal, and therefore he has approached the SEBI first.
Once it goes to SEBI,
Your Lordship.
once it goes to SEBI and SEBI starts taking action under the Act, but simpliciter, if a pawnee or pledgee of pledged shares proceeds to sell the shares, nothing goes before the SEBI.
Indeed, Your Lordship, because they are
At that time, a civil suit lies to restrain sale.
Indeed, Your Lordship.
But you say that since it has gone to SEBI, only SEBI can take action.
Your Lordship,
The jurisdiction of SEBI has been invoked.
Indeed, Your
The
Lordship.
public issue.
primarily because your lordship were not contesting whether the sale of the shares pledged were right or wrong. We are not contesting the price, your lordship. We are contesting whether the offer price made for the open offer upon the public announcement for acquiring the shares of the target company in which the applicant is a shareholder. We are challenging that offer price, your lordship. And in this regard, only SEBI, the board and the adjudication officer under the SEBI Act have the jurisdiction in no civil code, which is already provided primarily in this Act itself also, your lordship. Your lordship, if your lordship doesn't have any, if your lordship satisfied with the submissions of the council will proceed further. Much obliged, your lordship. Your lordship, the council also kindly seeks the attention of the bench to page number 19 of the memorandum submitted on behalf of the appellant, where the council has cited the PTC India Financial Services Limited versus Venkata Swallu Curry, which is a 2022 division bench judgment decided by this honorable court, your lordship, where it is settled that even for demat shares, the Indian Contractual Act will apply. And therefore, your lordship has humbly submitted previously the pledger, that is the appellant or the shareholder in this matter, will have all the rights that the pledger will have under the law of pledgers. Because your lordship fundamentally, because your lordship adhering to the need of flexibility in the transitional and commercial environment, the fundamental tenets of law of pledge should be applicable. It was cited in paragraph 26 of this PTC India Financial Services Limited case and has been also provided for the kind reference of the honorable bench in the compendium in page 177, paragraph number 26 for a kind resolution. With respect to that, your lordship, the council humbly submits that even though at the moment the council does not have not redeemed those shares, if they have a right to redeem those shares. And even your lordship, that is not what the council is seeking before this honorable bench. The council is seeking that we have also been grievance by the manner that we have shares in the target company, and those shares have been were intended to be acquired by the public by providing a public announcement, and in the public announcement the offer price is given ₹50, which is drastically undervalued than the offer price claimed by the plaintiff by the appellant for this present matter, which is ₹150. Your lordship, we are not contesting the price itself, we are contesting the process itself, your lordship. And for this submission, the council will also provide why such inaction of the SEBI is aggrieving the cause of the appellant. Your lordship, if your lordship is satisfied with the submission of the first issue 2, the council will like to summarize it and move to issue 4. Much obliged, your lordship. Your lordship, the council humbly submits before this honorable bench that under issue 2, the appellant is a shareholder primarily because he is still a registered beneficial owner of those pledged uninvoked 10% shares that are because primarily and the council is relying on regulation 79(8) of the SEBI Depositories and Participants Regulation 2018 and the judgment Clearing International versus Union of India of this honorable court, and submitting that they are a shareholder under the such regulation because primarily the shares they have a voting rights and the voting rights vest with the pledger. This is also held in the Ashwin Kumar case, which was also decided by this court, your lordship. Secondly, your lordship, the council also humbly submits that the appellant has a locus standi primarily because all other the SEBI, when the letter of representative letter was submitted to SEBI, the SEBI has already valuation before your election. It is provided that the appellant has insistently requested SEBI to intervene in this matter and stop the public open offer primarily because the share. Obviously. Regulatory body. Therefore, your lordship, the purpose of whenever there is a discretionary clause, whenever there is a discretion provided to section. Not relevant for this. Purpose is to protect the interest of the investors. The purpose is to regulate the
Interest of the investment is a very vague term, right? It's a very broad term. You have to be a little specific. You are saying that you don't agree with the valuation, right?
Indeed, Your Lordship.
Now there are three valuation reports.
Indeed, Your Lordship.
Talk about almost like the same amount, and then you want SEBI to appoint an independent
Indeed.
valuation. You want an independent body to value the price of the share.
Indeed.
Now this valuation business, the valuation of shares, it differs, right? It differs from experts to experts, right? Now you have to show some error, right? Some fundamental error in the valuation, and you have to show that this error was this error existed in all the three reports, right? Where have you shown that?
Your Lordship, Council seeks a moment, Your Lordship. national justice must be followed by appointing an independent valuer. Your Lordship, 4 valuation reports were submitted before the SEBI. 3 from the side of the respondent and 1 from the side of the appellant, Your Lordship. Now, Your Lordship, the value submitted by the respondent and the value submitted by the independent valuer of the appellant is wide, very wide. There is a difference of 100 rupees per share, Your Lordship. And in this regard, it is grossly loaded on the side of the acquirer, and if the value is coming to the 150, minimum 150, and such value is not recognized, then it is going to aggrieve the shareholders of the target company, Your Lordship. And appellant being a shareholder is aggrieved if such condition is not taken into account, Your Lordship. Secondly, Your Lordship, the council would like to cite that since it is a regulatory body, it is a corporate theory of regulating corporations which is intended to serve the public good. Your Lordship, in this regard, it is also submitted that if such price will not be taken into consideration, that is, if it is 150, it is coming out to be 150, then if such price will not be taken into consideration, then the shareholders will be aggrieved, and that will be against the public good. Secondly, Your Lordship, the council humbly submits that since the respondent, that all are coming to the close value, that is 45, 47, 50. Your Lordship, there may be a suggestion of quid pro quo in this regard. And so as to make a transparent decision, the council humbly submits that the SEBI must have appointed an independent valuer at the expense of the acquirer, so that the appellant did not have to come before this honorable Supreme Court to direct SEBI to issue to appoint an independent valuer. Your Lordship, not appointing an independent valuer has aggrieved not only one shareholders but all the shareholders of the target company. If only SEBI has appointed an independent valuer, and that at the expense of the acquirer, which is already provided in the provision, which is the law. If you have already appointed an independent valuer, then the council has not have to come all the way to this honorable Supreme Court to take a prayer for directing SEBI to appoint an independent valuer. Your Lordship, the council humbly submits that we are not contesting the price itself. We are not contesting that it is 150 only. We are contesting that it may be 150 because there are certain grounds, and it has to be minimum 150. Now, Your Lordship, that it is up to SEBI that since there are a lot of options, it has to use the council 2 minutes, Your Lordship, to humbly submit. Since it is a regulatory body, it has to follow the national principles of national justice. It is also provided under Regulation 32(2). And one of the principles of national justice is reasoned order, especially in case of an appealable order. Since this is an appealable order, when SEBI has chosen that their valuation report is correct and therefore approved the letter of offer, they have not given any reason, even though repeatedly asking for that. Your Lordship, that is the contention of the humble council. That show us the process, how we have come to the decision that their offer price is right and our offer price is not right. And for the transparency itself, we are pleading that an independent valuer must be appointed. It is not only this case, Your Lordship, it is also in the case of various previous judicial pronouncement, where whenever there is a more than one valuation report of various and drastically various valuations, the SEBI has appointed an independent valuer at the expense of the acquirer, so as to come to a decision which is fair, which is in the interest of the public shareholders, and which is also upholding the development and the promotion of the securities market, Your Lordship. That is the humble submission, and in just the council humbly submits and summarizes the issue for. Primarily, the regulation 816 and 32(1)(f) is to protect the interest, which is also written 32(1) itself talks about that whenever the question of interest of the shareholders and regulating the market securities is in concern, the SEBI will use the power under regulation 32. In this regard, it is the contention that there is an interest of the shareholders included. But SEBI did not follow the principles of national justice because it did not give a reasoned order, it did not follow transparent method to come into that direction, neither it has provided any reply, any action, including that it is an inaction, therefore it is an order because the consequence is fixed. The letter of offer has already been issued. Therefore, Your Lordship, they have grossly failed to uphold why they have been established in the first place. That is the humble submission of this council for the 14th. If there are no preliminary concerns of this nature in that regard, the council seeks permission to proceed with the prayer, Your Lordship. One question.
You don't have to answer.
Your Lordship.
You write a letter to the district magistrate. The district magistrate takes no action. You file application before a tribunal. The tribunal does not take it up. It is not even listed, not taken up. But you are angry by the action of pressure. From those actions, say permit district magistrate, from the inability of the tribunal to take up your matter or to come to anything positive decision. Can you prefer an appeal? Or what is your remedy?
Your Lordship, reasonable attempts has been made and all the remedies before going to the appeal has been exhausted, then the aggrieved person has the right to appeal.
Or first you have to find a writ directing the tribunal to take a decision.
Determined only, Your
And
Lordship.
then from that decision you have the right of appeal.
Your Lordship, the only contention that the council submits, that the SEBI has already provided an order. It is not like the SEBI has not replied. SEBI has already provided a forwarding letter that is in contest, and that is an order.
You are treating that as an order.
Indeed, Your Lordship, it is established as an order because there is consequence to it. If there has not been consequence, if the letter of offer has been stopped, then Your Lordship.
Your way of looking at
Your Lordship, there has been an order and that order we are appealing. The council is permitted to proceed to prayer. Much obliged, Your Lordship.
The reason for asking this question is that appeals are preferred against appellate orders.
Indeed, Your
There
Lordship.
was no order, therefore, whether the appeal was meant to be made. Right? If the authorities do not pass any order, we invoke the High Court.
Indeed, Your Lordship. Great
Article
jurisdiction.
226, Title 227. By inaction of the authority by not passing any order. But here you say the communication itself is an order, therefore it is applicable.
Your Lordship, in that the council humbly submits that all the procedure has been followed. And therefore, even after that, the SEBI take cognizance of the grievances of this appellant. It will become an academic exercise because I will have no right to issue because the shares has already been acquired, Your Lordship. In this regard, the council